Hello, everyone, and welcome to our program today entitled Youth Climate Litigation, Juliana versus United States. My name is Nina Fusik, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute, and I'm so delighted to welcome you today to our webinar. I would like to take a moment to thank our outstanding panelists for joining us today to lend their expertise to this important and timely topic. While I will introduce your moderator briefly, full speaker bios are posted on our website, eli.org, and I would encourage you to check out their experience in more detail there. At the end of our webinar, we will have time for a question and answer session. You can submit your questions through GoTo's question box, and please do not wait until the end. Send your questions as soon as you think of them. Here to moderate, I would like to welcome our moderator, Upasana Khatri. Upasana is a senior attorney with the Center for International Environmental Law, otherwise known as CIEL. She works with CIEL's Climate and Energy Program, where her work focuses on protecting human rights in the context of the climate crisis by supporting climate litigation and accountability efforts in close collaboration with CIEL's civil society partners and the communities they support. Before joining, Upasana advocated for the safety and well-being of unaccompanied and separated immigrant children in the Young Center for Immigrant Children's Rights. Prior to that, she worked for several years at Earth Rights International, where she helped implement litigation advocacy policy tools and strategies to support communities in advancing their rights and seeking redress for corporate and state-sponsored environmental harms and human rights abuses. Thank you so much for joining us, and we're so thrilled to have you moderating for us today, Upasana, and we cannot thank all of our panelists enough for joining us and lending their expertise with us today. With that, I'll turn things over to you. The floor is all yours. Thank you.
Thank you, Nina, so much for the introduction. And thank you all so much for joining today. This webinar is happening on the heels of a pretty momentous week in climate change news. Just to give a quick recap for those of you who might not know, last week a Dutch court ruled in a watershed decision that Shell must cut indirect and direct greenhouse gas emissions by 45% by 2030. We also witnessed victory in an Australian youth-led climate lawsuit and promising action from shareholders to hold big oil more accountable for their contributions to climate change. All that to say, I'm really excited to be part of this important conversation at such a critical time. So a big thanks to ELI for inviting me to moderate. We have a really impressive panel of legal experts and practitioners for you today, ones who have been true leaders in the field of environmental law and been at the forefront of the movement for climate change accountability. But before I turn it over to the panel, who will dive into the history of the case Juliana versus the United States, where the case stands today, and its legal significance in the wider context of climate change litigation, I want to take the next few minutes to zoom out and talk about how climate change puts the rights of children and future generations at stake, and the global trends we are seeing in response. Climate change is one of the greatest threats to human rights and to life on Earth as we know it. There's scientific and political consensus that greenhouse gas emissions from human activity, especially the burning of fossil fuels, is the primary cause of recent global warming. And what's really concerning is that there are children growing up today amid climate chaos who've only ever known this dim reality, one where natural disasters are becoming more frequent and more severe, tropical diseases are becoming more prevalent, tens of thousands of species are facing extinction, and many, many other impacts. And the science is clear, the effects of climate change will only worsen with each additional degree of warming. Climate change threatens children more than others, and that's because of many factors, physiological, socioeconomic, even geographic. Consider these facts. An estimated 500 million children live in flood-prone areas, and 160 million are exposed to severe droughts. Malnutrition is the contributing factor in 45% of all child deaths, and will be compounded by climate change. Rising temperatures and associated impacts also aggravate diseases and health conditions like diarrhea, malaria, and pneumonia, which are three major causes of death in children under 5. Also, the effects of climate change will magnify poverty, and a disproportionate number of children live in poverty. Climate change therefore threatens to aggravate children's existing vulnerabilities, putting them at exceptional risk compared to adults. Climate change and how we respond to it is therefore fundamentally about equity between generations, both between the older generations living today and between today's generations and future generations. Children will live more of their lives in the future than adults will, And we know that climate change impacts are getting worse, so the risk of harm over a child's lifetime will only increase. Those risks will have heavy tolls if we don't act now. So failing to take urgent action today won't just endanger the basic rights of those who will be alive to face that reality. It'll also cut off the voice and agency of today's youth and future generations, since decisions made today when they don't have a vote, both literally and figuratively, will shape what opportunities are available to them down the road. Now, you might be wondering how Juliana fits into this pretty grim picture I've painted for you. Well, Juliana is among a growing number of cases that are trying to compel urgent, ambitious action by spotlighting the disproportionate and discriminatory effect that climate change will have on children and future generations. And because they are youth-led, actions like Juliana are giving children a greater seat at the table today so that they can have a say in the decisions that will ultimately shape their futures. Even in the last 2 to 3 years, we have seen courts in numerous countries, from the Netherlands to Colombia to Germany, recognize in binding legal decisions the notion of intergenerational equity in the context of climate change and the need for governments to take more aggressive action to prevent present and future harms. This map, while not in any way exhaustive, gives us a sense of how widespread the youth-led climate movement has become just over the last few years. The yellow dots indicate some of the countries where youth-led cases or other cases that address intergenerational equity are either pending or have been decided, and that includes Juliana, which we'll see along the dot on the west coast of the US. I should highlight that in some cases, multiple states are the targets of the actions, not just the countries where the actions were brought. So in that sense, there should be even more dots on the map than portrayed. And there's no sign of this movement stopping or slowing down. Among the youth-led cases currently pending outside of the US are, going clockwise, a case currently before the South Korea Constitutional Court filed by 19 youth activists who allege that the country's climate law violates their fundamental rights, including the right to life and the right to a clean environment. There's also a case brought by Portuguese youth at the European Court of Human Rights, alleging 33 countries of violating their right to life by not doing enough to tackle the climate crisis. There's also litigation brought by Ugandan youth to compel the government of Uganda to protect children from the adverse effects of climate change. And finally, the first climate-related petition to the UN Committee on the Rights of the Child, the CRC, which was brought by 16 children from 12 countries and argues violations under the UN Convention on the Rights of the Child. This last case on this slide illustrates that in addition to the regional and national courts, we're starting to see an uptick in children-centered and youth-led advocacy before human rights treaty bodies, which monitor the implementation of core international human rights agreements. The work of these bodies is helping solidify the growing consensus in international law around states' duties in the context of climate change and with respect to the rights of children and future generations. And to give you a visual, one second, this first chart on the slide shows the increased attention that the treaty bodies have paid to climate change just over the last 12 years. I should note, however, that the sudden drop you'll see in 2020 was related to the pandemic and the overall decrease in the outputs during this period. Bodies like the CRC, which is portrayed in the bottom chart, have also highlighted the vulnerability of children and called on states to ensure their protection and their participation in climate decision-making. For example, in 2020 alone, the CRC highlighted the importance of children and youth participation in 9 out of 12 outputs to states that addressed climate change. This table gives you a glimpse of relevant language the treaty bodies have issued in recent years. Again, this is in no way exhaustive, but the point of highlighting these trends is to show the increased attention international legal bodies have given to the rights and vulnerabilities of youth and children, as well as the critical role they should play in setting climate policy and influencing climate law. As the Juliana case has shown, the impact of youth-led cases isn't just in the courts, but in their contribution to the greater climate movement and to public pressure for needed change. Even after numerous wins, including last week's decision from Australia, cases like Juliana continue to face challenges in court, such as questions around judiciability and remedy. Still, despite these lingering challenges, Juliana has created an important opportunity today for the current US administration. The Biden administration now has a chance to live up to its promises made on the campaign trail to protect the rights of children and future generations. And it can do this through ambitious emissions cuts and by halting fossil fuel development and the other drivers of climate change. And with that very hopefully simplified overview, I want to turn it over to our first panelist, Julia Alston. Julia is the founder, the executive director, and chief legal counsel of Our Children's Trust, a nonprofit public interest law firm that provides strategic, campaign-based legal services to youth from diverse backgrounds to secure their legal rights to a safe climate. Julia graduated from UC Hastings College of Law in 1997 and founded Our Children's Trust in 2010, initiating a global wave of rights-based climate litigation, especially cases brought on behalf of children. Julia is lead counsel in Juliana versus the United States. Please join me in welcoming Julia Alston.
Thank you so much for that kind introduction. And let me see if I can get my PowerPoint working. All right. It's great to be here with Jeff and Lisa and Upasana, and thank you, Nina, for bringing us all together for this important conversation today. It'd be nice to be in person. We'll do that soon, hopefully. So I'm gonna first just start by talking about our 3 principles at Our Children's Trust for people who are not as familiar with us. We do one thing: we advocate on behalf of youth and future generations for their climate rights. And in doing so, we're very committed to finding science-based and legally enforceable systemic remedies through courts or other processes. And our bottom line is we want to protect the human rights of our children. And this is Aji, he's one of our plaintiffs, and just a quote from Mary Robinson about everything that Upasana has just described in the way children are being affected by this crisis. Here's my crew. These are 21 amazing young citizens of the US who have taken on this monumental task of really trying to hold their government accountable for not violating their fundamental constitutional rights. And one thing, at the outset that I want to remind everyone about is this case at its heart is a children's case. So yes, it's about rights to life and liberty and personal security and equal protection of the law and the protection of our public trust resources, which government is obligated to protect for this and future generations. But it is at its heart about children, and they are special for all the reasons Upasana discussed, and I'll touch on too. So there's a very long history in this case, and I'm going to highlight some key moments. This November 2016 decision by the district court judge was really profound. I think it will be historic when we look back in terms of the role of courts in this crisis. It was the first time that I know of a court really said that the climate system capable of sustaining human life is fundamental to a free and ordered society. And in finding that, what Judge Aiken wrote about in her opinion denying the motions to dismiss of the government and the industry interveners at the time is that the complaint wasn't challenging the United States government's failure to act on climate. And this is a really key point because a lot of people misunderstand this. We are challenging the affirmative and substantial action of the government that is contributing to this climate crisis. So we're going after their affirmative conduct, not their failure to do something. And just showing you this, it's been a really complex 6 years. The light green are the different key moments in the district court. The gray represents our trips up to the Ninth Circuit, where the government took us up there. And then the orange are trips up to the Supreme Court on government's applications for emergency stays and mandamus petitions. So it's been a wild ride, and I'm going to bring us up to the last couple of years. But before I do that, I want to just go over everything that the plaintiffs have won on so far, which is substantial. So plaintiffs have established that they have valid Fifth Amendment claims that can be brought under the Substantive Due Process Clause. Their claims are not precluded by the political question doctrine. Their claims are not precluded by a general separation of powers argument that the government made about courts of chancery and claims that could be brought there historically. The courts have found that plaintiffs can bring their Fifth Amendment claims directly under the Constitution, just as in other constitutional cases, and they don't have to use the Administrative Procedure Act. And plaintiffs have established that they can challenge systemic government conduct. They've established that they're injured and that the federal defendants are a substantial cause of their injuries. So the key question when we were taken up on interlocutory appeal to the Ninth Circuit in 2019 and 2020, the court was addressing this fundamental question that courts around the world have addressed, and it is, can children and youth go to court to protect their fundamental rights? And here in the US, as in many jurisdictions, the questions are, do they bring forward personal injuries? Are the defendants a cause of the harm that they're experiencing? And can the court provide a remedy? So the first two we won on, and the third is where the Ninth Circuit was hung up. So I'm just going to walk through the first two prongs, because I think the findings of the Ninth Circuit in its ruling are really important, and we're starting to see these same kinds of findings in cases around the world. So we had copious expert evidence in the record that this rise of carbon dioxide levels is wreaking havoc on Earth's climate, and it's largely from fossil fuel combustion. The majority found that these levels had skyrocketed. We haven't seen them in 3 million years. They relied on NASA data to establish that. And, this is a recent NOAA chart showing the change in annual temperature compared to the 20th century. And, we're off the charts, heating up, drying out, and experiencing extreme weather conditions, all of which the majority recognized. So the heat is causing the ice to melt, obviously, and sea level rise. And the evidence in the record showed that by 2100, we could see sea level rise of 15 to 30 feet. And then, from that big picture climate system issue, the court drills down into, well, how is this affecting the individual plaintiffs? And the court found, based on our evidence, that there were exacerbated medical conditions, damage to their family property, and psychological harm, among other injuries. The climate fires we experienced out west last summer are emblematic of this. We're looking toward another really dangerous wildfire season here in the West. And, this is the majority saying we're at a point of no return. Without action, this destabilized climate will bury cities, spawn life-threatening disasters, jeopardize food and water supplies. This is our plaintiff, Alex, with his girlfriend. That's an unadulterated photo of last summer in Southern Oregon on Alex's farm. And then Isaac and Tia, all three, Alex, Isaac, and Tia, all suffer from asthma, and their conditions are getting worse. Their security and their ability to live is threatened by this crisis. So then moving from injury, the court turns to, well, what's the government's role? And it found that there's a substantial evidentiary record documenting that the federal government has long promoted fossil fuel use despite knowing that it can cause catastrophic climate change. And the failure to change that existing policy may hasten an environmental apocalypse. You don't read things like this in many court opinions, right? And so one of the key issues in the evidence we put forward is the fact that the United States is expanding oil and gas extraction 4 times faster than any other nation. And the dissent picks up on this and says, this is an existential threat actively backed by the government. This is an example of one of the exhibits in the record that shows, this is not a new problem. This is an ongoing problem, since the 1950s and 60s, when government really knew what was happening with fossil fuel emissions. And yet our production in the US just continued to increase, including under the Obama administration and the Trump administration. And this, I just pulled these graphs from our energy EIA data. This was from this spring. And even now under the Biden administration, projections still show natural gas production going up, oil production going up, and consumption and at best flatlining through 2050. So we still have a real problem on our hands in terms of the system our government is perpetuating. And I'm going to skip over a few slides because I'm a little short on time. But so then, we're through causation, we get to the issue of redressability. And this is where the majority and the dissent disagree. And the majority opinion focused on one request for relief in the plaintiff's complaint. It really honed in on that and addressed whether the court could issue an order requiring the government to develop a plan to phase out fossil fuel emissions and draw down excess atmospheric carbon dioxide. And ultimately, the majority said that the court didn't have authority to do that. And here, this part of the Ninth Circuit decision, from my perspective, is one of the more frustrating pieces, because the court does this analysis and says, look, this is an impressive case for redress. These plaintiffs are harmed. The government's causing it, but they need to go to the political branches for their remedy, or they can go to the ballot box. And at the time we filed this case, these children didn't have voting rights, and many of them still don't. Some of them have come of age, but we have children who have no rights of suffrage. They have no money to lobby. They are the politically powerless in our country. And the dissent discusses this in her opinion. She says that fundamental rights may not be submitted to vote. They depend on the outcome of no elections. And I think that's really critical, that our fundamental constitutional rights don't get to be decided by the majority who's in power, and especially when kids have no ability to affect that. And then finally, the dissent lays out really powerful arguments and ultimately says that the government is bluntly insisting that it has the absolute and unreviewable power to destroy the nation, and that the courts have no role to play. And that's really the crux of where we're at in the case. Before I turn to what we've done since that opinion, I just want to point out that there are many, many examples in our history and our court system where systemic remedies, plans for redressing constitutional violations have been a core part of what our judiciary has ordered and overseen. And these are just a few of those examples. And Brown versus Board of Education has always been a source of inspiration and legal authority for us. And I think it hones in on where the Juliana case really needs to go. And it's what the Supreme Court did in 1954 with segregation, where it said the primary question is not what appropriate relief may be necessary, what injunctive relief we should order. The primary question is the constitutionality of segregation in public education. And right now, the question the US courts need to address is the constitutionality of a fossil fuel-based energy system, and whether that can continue and whether it's consistent with protecting the opportunity for young people to hold their fundamental rights and have their liberties. So after being denied en banc review by the Ninth Circuit, we are back in the district court, and we have made a Rule 15 motion to amend. And the reason for that is the dismissal by the Ninth Circuit based on lack of redressability was a dismissal without prejudice, as are all jurisdictional dismissals. The Ninth Circuit did not decide standing on the merits of the case. Again, we were up on a denial of the government's motion for summary judgment, so there had been no merits decision at that point that the Ninth Circuit could even review on interlocutory appeal. And the parties agree that there's no prejudice, there's no bad faith, there's no undue delay in seeking a a motion to amend. Injury in fact and causation are found. And so really the issue before the district court is the amendment futile? And what we are asking the court to do is to not consider our request for relief about the remedial plan, but let's just focus on the Declaratory Judgment Act and really getting that declaration of law in the first instance, and then considering further injunctive relief later if necessary, in the same order that Brown v. Board was decided. And I'm gonna skip that too. I wanna just mention this case, the Uzigbunham versus Prochaski case, which was an opinion written by Justice Thomas. And this was a standing case where injury in fact and causation were proven, but the conduct of the government in a First Amendment case had ceased. And so it was really a case that was moot. But the Supreme Court said that because the plaintiffs sought $1 in nominal damages, that there was enough for redressability. And the reason for that is that nominal damages are a form of declaratory relief, and declaratory relief is enough for standing. So I think this question of whether the Juliana plaintiffs have standing should really be a cut and dry issue for the courts. So we have oral arguments scheduled on June 25th on the motion to amend in the district court. Meanwhile, the district court has ordered the plaintiffs and defendants to the settlement table, and we will also be engaging in a confidential settlement negotiation process with the government this month. And when Judge Aiken directed the parties to do that, she really focused on the fact that, in these really big, complex issues and cases, having the court's assistance in bringing the parties together and having the three branches of government work towards a solution can be really effective. And we've seen that in many other cases, including here in the Northwest, the treaties rights cases that have been brought to protect fisheries involve, I think, 8 or 9 sovereigns are at the table with the court's help in regularly coming up with plans and agreements to protect the parties' rights to their fisheries. So, the process of settlement will be a confidential process, but I just wanted to mention frameworks for settlements and consent decrees that we see in other cases and that we think can be applicable here. So settlement agreements can declare what the problem is and the rights that are at stake. They can provide a framework for protecting the rights. They can provide standards, benchmarks, and timetables, mechanisms for compliance, procedures for ensuring that the agreement is abided by. And then parties and courts will often make use of special masters or technical and policy committees in really complex matters. And then, of course, there are provisions for conflict resolution. Well, I want to just touch on this briefly. I'm not going to go into the science, but one thing that is critical in the Juliana case is that our courts don't set standards, and that any resolution of this case involves a standard that would actually protect the human rights of our plaintiffs. And already at the levels of heating that we've experienced, which is about 1.2 degrees Celsius rise in temperatures at this point, we have catastrophic impacts and a dangerous climate situation for these youth. And so we're really looking at what scientists tell us we need, which is to reduce levels of carbon dioxide to below 350 parts per million this century, and not looking at the temperature standards of 1.5 or 2 degrees Celsius that the international community has adopted, because those levels of heating are catastrophic for these kids. And the great news is, in the expert evidence that we have in the case, if we're looking at needing to move away from fossil fuels completely by 2050, it's economically viable and it's technically feasible to do so. So this is just one example of one study that shows that the costs of energy that consumers will experience are actually on the low end and levelize over time when you're looking at transitioning to renewables. And I'm just checking to see how much time I have left. Okay, I have a couple minutes. So Next steps, we are, whoops, I went the wrong way. Sorry. We'll argue the motion to amend if we need to, hopefully get to trial. Hopefully the Biden administration's DOJ will not take the same extreme measures the Trump administration took for 4 years in trying to deny these children access to their courts. We could go up to the Supreme Court on a petition for a writ of cert, or we could resolve the case through settlement. So those are kind of the 3 pathways we're looking at right now, and hoping to have meaningful settlement negotiations, but also ready to prepare for trial if needed. And then just to build on a little bit of what Upasana discussed at the beginning, these are mostly youth cases around the world. Some are other citizen rights-based cases. And it just shows like these cases are expounding. I mean, they're growing exponentially. And we brought, the first youth cases in 2011 was when OCT launched this effort. And since then, we're just seeing more and more and more youth and lawyers rising up to represent youth around the world. And what we're seeing in this effort is that the US courts are outliers among democracies in terms of how our judiciary is responding to these claims. Upasana talked about some of these cases in Germany and the Netherlands and Colombia, Pakistan, Ireland, France, Norway. Like, these courts are saying, yes, you can walk through the doors. And some of the youth are winning and some are losing, but they're getting access to justice. And I just want to end on this quote from the Australia decision that came down last week. And they said, like our Ninth Circuit, like Judge Aiken, like some of these other opinions, that it's difficult to characterize the devastation that the plausible evidence presented forecast for children. That the world we know it will be gone, the physical environment will be harsher, far more extreme, and devastatingly brutal and angry. Trauma will be far more common, right? So they're talking about really existential, catastrophic harm to children and acknowledging it and saying that it's the greatest intergenerational injustice ever inflicted by one generation of humans upon the next. And if courts don't have a role to play in that, then I don't understand what democracy is all about. And so on that note, I will end and turn it back over to Nina and Upasana. Or actually, maybe I'm just turning it over to you, Jeff.
Thanks, Julia.
I'll go ahead and introduce Jeff. Thank you again, Julia. That was a very enlightening, thorough presentation. I'm sure folks have questions, which we'll save to the end. But let me just make sure that we have the presentation lined up. Okay. So I want to introduce our next panelist, Jeffrey Wood. Jeff is a partner in the Washington, D.C. office of Baker Botts LLP and has practiced environmental law for almost 2 decades. Prior to joining Baker Botts, Jeff served as the acting assistant attorney general for the Justice Department's Environment and Natural Resources Division, the ENRD. In that capacity, he led the ENRD and its more than 600 attorneys and staff representing the EPA, the Departments of the Interior, Energy and Defense, and other agencies in civil and criminal enforcement and defense of environmental, energy, and natural resources litigation. At the DOJ, Jeff was deeply involved in the federal government's litigation strategy in the Juliana case throughout 2017 and 2018. Previously, Jeff also served on the staff of the U.S. Senate Environment and Public Works Committee. Welcome, Jeff Wood.
Thank you so much. It's really a pleasure to be here. And I really just applaud the work of the Environmental Law Institute for bringing this panel together. ELI does a fabulous job covering a whole wide range of environmental law topics, helping to educate the public and inform lawyers and keep us up to date on the latest developments in environmental law. So I really want to just applaud the work of ELI. Really been a big fan for many years. So thank you for this opportunity to join such a distinguished panel. I wanted to just, in this time I have, sort of the claims that are at issue, give a sense for, I'm not here talking on behalf of the federal government, but give a sense for the government's longstanding position on the key issues in this case. This was a lawsuit, the Juliana case filed during the Obama administration tenure. It was inherited by the Trump administration and has now been picked up by the Biden administration. But for the most part, there's some differences in aspects of how the case was handled for sure. But for the most part, the government's position has been remarkably consistent throughout. The Obama administration moved to dismiss the case when it was originally filed. And then the Trump administration came in and also sought judgment on the pleadings and summary judgment and moved for expedited relief on appeal. And now I think just reading the most recent filings during the Biden administration, there's been a continued focus by the government on seeking denial and ultimate dismissal of this case. So I'll talk a little bit about the government's arguments and why those are being made. And then I did want to spend a few minutes at the end just touching on the topic that Julia raised, which is this interesting new approach towards settlement that's been raised here in the last month or so. And I had some thoughts that I wanted to share with the audience just on where that might be headed. So ultimately, I think the key issue I just want to emphasize in my remarks is that it's important to preserve the prerogative of the elected branches to make the decisions about how the United States addresses climate change and energy policy. It's exactly the kind of issue that our Constitution preserves to the elected branches, and that's an important principle, not to demean or disparage the claims that were brought, or to say that there aren't arguments that should be raised to the federal government, but it's to say that the right audience for that argument is with the elected branches, where it's been debated for years, and in fact, we're seeing progress. So if you look at the latest data, and this actually doesn't even include 2020, where we saw an even more significant downturn, since 2005, net emissions of greenhouse gases in the United States have dropped 13%. That's since 2005. That's through 2019, doesn't include 2019 or 2020. We've gone from around 6,600 million metric tons equivalent of CO2 to around 5,700 million metric tons equivalent CO2 in 2019 for net GHG emissions. So the United States is moving in the right direction, and the Biden administration, I think Julia and her clients are likely pleased with some of what they're seeing, but they're bringing a whole of government approach to this topic as a result of being elected and being brought into office. You've had new appointees nominated and confirmed. You've had new executive orders issued by President Biden on climate. You've had new agency directives by virtually every agency, shifting budget priorities, changing organizational programming, changes in enforcement priorities, a new look at permitting and licensing processes, as well as additional initiatives with the private sector, federal state partnerships, and new legislation. So all the ways that the United States government, in response to an election, can shift and change and move a different direction. The plaintiffs are seeing that happen, which is the way that our government's designed to work. There are a variety of categories of climate litigation, and I'm not going to go into detail on this, but I just want to put the youth climate case in context. You have a variety of statutory and administrative law challenges that are brought to agency action. We see this every day in our country in the federal courts. If an agency takes an action that an injured plaintiff does not think is lawful, they can challenge that in federal court. And there are a variety of statutes that give those rights and protections. Also, licenses and permitting challenges. When a new project, a new pipeline, and a new leasing agreement is entered, when a new infrastructure project is brought online, we often in our country see litigation brought that's heard in federal court as to whether environmental equities were properly concerned, whether that's under the National Environmental Policy Act or other statutes. And then there are a variety of other kind of torts and nuisance cases that we've seen lately. But the one obviously that we're here to talk about today is a unique flavor of climate litigation. And those are cases brought under the US Constitution under a theory that there's some right to a stable climate system. Now, when we talk about the US Constitution and the claims that are brought under it, I do think it's important for the audience just to take a step back and think about some broader principles. First of all, uniquely, our United States Constitution establishes three co-equal and separate branches of government. And those branches of government are invested with certain powers that the Constitution grants to them. The legislative powers, those that are granted in the Constitution, are given to Congress, and they're listed in Section 8 of Article 1. The right to borrow money, the right to regulate commerce between the states, the right to declare war, and so on and so forth. Then there's the executive powers and the obligation of the executive branch to take care that the laws are faithfully executed. And this includes basically the power to control the doing of federal law, the power to execute, the power to do federal law to make sure it's accomplished. And that's resting with the executive branch. Those are what we call the two elected branches.
Looks like Jeff is frozen.
Yeah, Jeff, I don't know if you hear us, but you're currently frozen and we can't hear.
I could continue with the presentation. I know all of these arguments really well.
Hello, this is Nina speaking. Jeff, if you can hear me, you can try turning off your camera to increase the speed of the connection. Alternatively, we'll just wait one more moment to see if Jeff's connection can come back. Thank you all for your patience. Jeff, can you hear us? All right, well, just in the interest of time, while Jeff is joining back on, we'll just skip ahead to Lisa's presentation, which is the presentation following, and then we'll go back to Jeffries once he's able to rejoin us.
Thanks,
Perfect.
Nina. Thank you so much, Nina. And I just wanted to note that our next panelist will be joining only by audio due to some technical difficulties. And she is Professor Lisa Heinzerling. Lisa Heinzerling is the Justice William J. Brenner Jr. Professor of Law at the Georgetown University Law Center. Her primary specialties are environmental and administrative law. She has published several books, including a leading casebook on environmental law, a then novel casebook aimed at introducing first-year law students to the regulatory and administrative state, and a hard-hitting critique of the use of cost-benefit analysis in environmental policy. Professor Heinzerling has served as lead author of the winning briefs in the Massachusetts versus EPA, in which the Supreme Court held that the Clean Air Act gives the EPA the authority to regulate greenhouse gases. From January 2009 to July 2009, Professor Heinzerling served as Senior Climate Policy Counsel to the Administrator of the EPA, and from July 2009 to December 2010, she served as Associate Administrator of the EPA's Office of Policy. In 2008, she served as a member of President Obama's EPA transition team. Welcome, Professor Lisa Heinzerling.
Thank you. I assume you can hear me. Is that correct? Yes? All right. My camera appears not to be talking to GoToWebinar, and so that's why I'm only here as a voice and not as in video. So I want to talk about the court's refusal to hear the claims of the children in Juliana. And Nina, if you could move to the next slide. No, go back one. Thank you. So the hearing is a fundamental part of the United States legal system. And yet on the eve of trial in the Juliana case, and of course the trial is the classic American ritual for being heard, for presenting one's case, for being known or appreciated. It's a way to know that the American legal system can hear your voice in the most basic sense. On the eve of trial, the United States Supreme Court panicked. While acknowledging that the case was not actually in a posture in which the Supreme Court's intervention was appropriate, and without full briefing or argument, the Supreme Court issued an order strongly hinting that the trial, the hearing of the children's claims, should not move forward. The court did this in response to a kind of panic induced in the United States government itself, as it contemplated the prospect of defending its decades-long support and promotion of the fossil fuel edifice, as the plaintiffs have called it. In asking the Supreme Court to stop the trial, the government claims that the trial itself would violate the separation of powers. And so the United States government responded to the prospect of holding a trial, a hearing, an event that happens every day in every courthouse in this country, on the plaintiff's claim as a kind of affront. The tone of the government's brief in arguing against a trial suggested it was somehow outrageous that the plaintiffs even asked to be heard. So I guess the question I want to ask today is, what legal principle made it so imperative not to hear the children's claims? Why did the government seem to think the republic would fall if a trial court in Oregon heard these children's claims about the harms of climate change to them? It was, of course, the separation of powers. If we could move to the next slide. This is, of course, the idea, and we've already heard about this from Julia, and Jeff was on his way to talking about it as well, is the idea that three principal institutions of our government, the legislature, the executive, and the courts, are separate and independent. And crucially, the idea also has to be that we can easily, clearly, and predictably tell these three institutions apart. If we can't do that, then we face the problem that the separation of powers, as we call it, is just a neutral sounding way of shoveling power to the courts to decide when they will choose or won't choose to let claims be heard. So I think how Justice Scalia, himself a great hawk on the separation of powers, how he chose to answer the question of how we know what the difference among these institutions is, and therefore what it is that courts should just do and what they should just not do. How did he tell this? How did he tell when they should listen to a claim, hear a claim, or not hear it? Common understanding. Right? Common understanding. There are some things courts just don't do, and we know them when we see them. It's just never a good thing when a constitutional test looks like Potter Stewart's infamous test for judging obscenity under the First Amendment. We know it when we see it. And that's, I think, what the court's test about hearing claims is very much like. Whose common understanding are we talking about? Whose common understanding of what courts do and don't do is Justice Scalia taking into account? And so here I think it becomes vitally important, if we could have the next slide, please, to think about what we've already talked about today. That is, there are institutions in other countries all over the world. They call themselves courts. They operate as courts. No one in those countries suggests they are not courts or that this isn't something they do. And yet in those countries, courts are hearing claims like the Juliana plaintiff's claims. They are hearing them and indeed accepting them, as we've heard about today. They're accepting claims that courts and other institutions violated a constitutional or human rights obligation in their actions with respect to climate change. And as we've heard today, last week, courts in the Netherlands and Australia handed significant victories to plaintiffs in environmental lawsuits. Same thing for Germany, India, and many other countries that are where courts that everyone believes are courts and do not cease to be courts because they hear these claims. Courts are hearing these claims all around the world. And so what makes the United States different? What makes our courts so special that they simply panic at the prospect of hearing the claims of children with respect to climate change? I think it has to do with Article 3, and this Jeff was starting to talk about as well. Could we have the next slide? So maybe it's the language of our Constitution itself that explains why the United States, seemingly increasingly alone among the countries in the world, simply says its courts are unable to even hear, just listen to these claims. Maybe it's the language of the Constitution. Maybe the words of the Constitution themselves dictate that claims like these must not be heard. Well, problem is not really. Here are the words of the Constitution on this point: judicial power, cases, controversies. Now, these are important words. They don't answer the central questions. We need to have a whole lot of instinct and impulse and priors to understand the separation of powers jurisprudence that is followed from these really simple, vague, almost cryptic words in the Constitution. So I would submit, and there's much more I could say here, but I would submit the words don't do it. They don't explain the difference in the United States in this respect. So maybe we go back to the common understanding that Justice Scalia talked about. And yet, this seems, as I've suggested, and then I'll now elaborate in more detail, deeply unsatisfactory. It exposes us to the possibility that there will be judicial bias in the decisions, even at the basic level of who gets heard. Not who wins at the end of the day, but simply who gets heard. So let me tell you about two cases that made their way to the Supreme Court in the same month, in October 2018. We have the next slide, please. In the fall of 2018, two cases came to the Supreme Court. Both involved due process. Both involved the parties' preferred ways of dealing with climate change. But only one of these was presented as a case in which the Supreme Court should panic upon the prospect of the courts hearing the claim. So in Juliana, of course, we know, the claim was that it violated the separation of powers even to hear from the children. The constitutional claims there sounded in substantive due process. The Supreme Court, in its brief order on the case, said that they were unprecedented legal theories, and the government argued that merely hearing them would be an affront to the authority of the executive branch and overreach in terms of judicial power. So the claims themselves should not be heard, must not be heard, because that's not what courts do. At the same time, ExxonMobil was asking the Supreme Court to hear its due process case relating to climate change. Exxon wanted the Supreme Court to protect it from Massachusetts' investigation into Exxon's long history of publicly denying the scientific facts of climate change. Exxon asked the Supreme Court to enlarge its due process protections against being subject to suit in Massachusetts. If you remember your first year civil procedure class, the due process claim that it was asserting had to do with the limits on personal jurisdiction in various states based on various circumstances. So now the Supreme Court declined review in the Exxon case. It didn't accept Exxon's petition for review. But here's my observation. No one in that case, I mean no one, argued that Exxon's case didn't belong in the federal court. No one said it would be an affront to the executive branch or an affront to the sort of authentic power of the federal court to hear that claim. The court simply dealt with the case as they would any other case. It slipped its way into the federal courts and then quietly left. No one argued that the republic would fall if we heard that case. And yet the cases have exactly the same structure. In both cases, substantive due process was being argued. In both cases, there was a request for an enlargement of substantive due process rights. And crucially, in both cases, the argument really turned on the plaintiff's preferred ways of having the government deal with climate change. In Juliana, the preferred way was to have the court require more from the federal government. In Exxon, it was for the court to allow less intervention by the government of Massachusetts. So it seems to me that here too we have a case of we know it when we see it, right? Everyone just knew Juliana didn't belong there, and yet no one thought Exxon didn't belong there. I worry about what instincts and priors lie behind that sort of automatic judgment about what belongs in court and what doesn't. So let's think, we see the next slide, please. Maybe the United States is different only for constitutional cases. And maybe if there's a statutory case, like I think the first category of cases that Jeffrey Wood offered up in the slide, maybe when they hear or are faced with cases involving statutory obligations, maybe there they'll hear the case. So maybe the bias that I'm suggesting in deciding who gets heard, maybe that only exists for constitutional cases, right? Maybe Exxon's claim was fine because it was based on a long-standing due process idea, and Juliana was different. No. Sadly, that's not the answer either. Massachusetts versus EPA, of course, the majority held that the Environmental Protection Agency had the authority to regulate greenhouse gases under the Clean Air Act, and held that the states and other environmental petitioners had standing to challenge EPA's failure to regulate greenhouse gases under the Clean Air Act. It was a statutory case that the plaintiffs undoubtedly had the statutory power to bring. Nevertheless, four justices dissented, led by Chief Justice Roberts. They know there's no standing here. It didn't matter that it was a statutory case. It didn't matter that there was statutory power to bring the case. There was simply no standing to sue. The case didn't belong, in other words, in the United States courts, even though it wasn't a constitutional court case. And even though, to put it in just terms, people had recurred to the political branches and gotten action, it was called the Clean Air Act, right? And even there, no authority to sue in federal court. So compare that case to Juliana, and I think you'll find a puzzle. Unlike in Juliana, where the Ninth Circuit held that the case was just too big for the federal court, the claims were too expansive, they were too bold, Chief Justice Roberts in Massachusetts versus EPA found that the case was just too small. Right? It was just one program under one federal statute, and so it wouldn't do enough good to even justify hearing the case in federal court. In fact, he intimates here in this quote on the slide that maybe the claim wasn't even sincere because it was so small. So you figure it out because I can't. The claim too big, that's Juliana. Is it too small? That's Massachusetts versus EPA in dissent. Right? So what exactly is the right size claim with respect to climate change? Another example, because we get the next slide, please. So let's see if we can try one last time to rescue the courts from the charge of bias in determining who gets heard. Even if the courts won't hear climate-related constitutional claims, if those claims are asking courts to force rather than avoid action on climate, and even if the courts won't hear statutory claims seeking to force the government to act, surely you might say the courts also then have to be even-handed, they must deny claims challenging government action on climate, right? Otherwise, that would just be so patently skewed. Sadly, again, no, right? So Massachusetts versus EPA, on a statutory claim that EPA failed to act, 4 justices said no standing to sue. The EPA uses that authority to regulate stationary sources. That rule is challenged in a case called Utility Air Regulatory Group. And in that case, again, just without even a hint that it might not belong there, the court says, yeah, sure. Not only will we take this case, not only will we hear this case, but let's go ahead and strike down that rule. Right? So that here too, it's just hard for me just looking at this to understand why we have this few, and even just the cases that will be heard, and why it's so obvious to so many judges which cases belong in which category. So I guess the question is, after all this, is does the Supreme Court's common understanding, to use Justice Scalia's phrase, is a common understanding of what courts do simply mean litigate seeking ambitious action on climate change are disfavored in the courts? Is that what we're saying? I think yes, right? And here's a striking thing. Can we see the next slide? For Justice Scalia, that was just fine. And here we have him in an article, a law review article before he became a judge, talking about standing, arguing against standing for rights broadly shared among the population, and saying, does this mean that important legislative purposes will get misdirected or lost? Yes, yes, and a good thing too. So not only, yeah, we have a bias in our law of standing, but it's a good thing because some statutes just won't happen in operation. They just won't actually work out the way Congress intended, and that's all right. So when I get to this point in the presentation, I am really, really not convinced at all by the idea that the Juliana plaintiffs lost because they had to recur to Congress, right? You have something, a frank acknowledgement of the skew in justiciability doctrine, like Justice Scalia gave us. It seems to me to stop talking about how some plaintiffs lose simply because they didn't go to political branches. So courts often justify their refusals to hear cases by invoking liberty. Let's just turn to the last slide. We'll be more free, they suggest, if the courts stay their hand, if they decline to get involved in certain kinds of cases. And yet, here's the basic message here. Whose liberty are the courts actually trying to protect in cases like Juliana? It's not the liberty of all of us. It's the liberty of a small few of us. And that's clear, it seems to me, from Hugh's interpretation of the separation of powers the court embraces, true certainly from Justice Scalia's frank acknowledgement of the bias in this area of law. And maybe the courts recognize this. Maybe they see that this is biased, and that's why they seem to feel the need not only to deny claims like these made by the children in Juliana, but to almost belittle them. In this quote, the Ninth Circuit suggests it will be converted into a character like Don Quixote if it hears the children's claims. It'll be party to a futile and somewhat demeaning quest for justice. Could I have the last slide?
Excellent, thank you. This is Nina speaking. We'll just jump.
No. I've got one more thing to say. There's one more slide, but it's not a problem. I'll tell you what it is. It's a windmill. And the question is, who's tilting that windmill really now? So the idea is that the courts, it seems to me, in the United States are in a kind of rearguard action, seeking to protect themselves and to maintain a kind of old-fashioned nostalgic view about what they think courts do. So to me, it's not the kids who are the knight errants, and not the courts who might hear the kids who are the knight errants on a futile quest. I think it's actually the federal courts. So thanks so much.
Perfect. Thank you, Lisa. We'll quickly jump back to the end of Jeffrey's slides.
Yeah, thank you so much. I'm sorry to have been disconnected. I'm not sure what happened there, but I did want to just talk a few minutes about, and I know we want to move on to questions, so I won't dwell longer on this, but we can actually start right there. That'd be a great spot. So, I think this touches on something we just heard Professor Heinzerling ask about, which is, what was problematic about a trial and why did the court step in here? And I think for those observers who were watching what the Supreme Court was saying in 2018, it wouldn't have been surprising to see where the Ninth Circuit ultimately landed in 2020 and where we are today. And that was the Supreme Court in July of 2018, when the government asked the court to get involved. The Supreme Court, and I respect Professor Heinzeling's view on this, but the court didn't go out of its way to do anything other than to point the parties to the governing statute, 28 U.S.C. 1292b, which essentially says that trial courts don't entertain comprehensive, massive trials when there are substantial grounds for differing opinions as to controlling issues of law. And that's exactly what we had here. We had a district court who was recognizing for the first time a fundamental right that no other court had ever recognized in the United States, a court that was ignoring the basic, and I'll say neutral principles of standing, injury in fact, causation, and redressability, which has been the key Achilles heel for the plaintiff's case all along, ignoring those and pushing for a 50-day trial where the defendant is none other than the executive offices held by the president as well as the senior cabinet members, a massive trial. So that's exactly the context in which 1292B makes perfect sense. And the Supreme Court, in denying the government's request for a stay, was pointing the lower courts, the Ninth Circuit and the District Court, to the statute when they issued their very short stay orders. The court repeated it again in November 2018. They had stayed the trial that had been set for October of 2018, and the court pointed again to the substantial grounds for difference of opinion, which is essentially directing the courts and the parties to pay attention to 28 U.S.C. 1292 and to allow these questions about, is there a fundamental right? Is there even standing here, to be heard before undertaking a massive, intrusive trial of the kind that was contemplated. So I'll skip over that. And then ultimately, what did the Ninth Circuit do in light of that? Well, the Ninth Circuit, as Professor Heinzling has explained, denied standing and denied a case here for plaintiffs. And I think it's important to remember the court didn't just say, remand it back to the district court to take steps in light of this opinion. The opinion concludes by saying, we reverse those orders of the district court and we remand this case to the district court with instructions to dismiss for lack of Article 3 standing. So it's not as though this case is being held over in some way. The court has directed what should happen on remand, which is dismissal. And I give credit to Julia Olson and her really terrific legal team. They've come up with an idea, a way to try to keep the case alive, while they also evaluate whether to take this case up for further review. And I won't dwell here for lack of time. But what would settlement talks encompass? I heard Julia mention the possibility of a consent decree, but the government isn't given carte blanche to enter settlements with any party. And these are, again, neutral principles. I'm sure there are a lot of groups on the right that would have liked to run in and try to enter a favorable settlement with the government on a variety of issues and force some sort of outcome. But the parties being directed to initiate settlement discussions runs counter to the idea that the Ninth Circuit, the more senior court, has already ordered dismissal of the suit. So I guess the question I have is there a basis for continued jurisdiction at the district court level to press for mediation? And I understand the court will evaluate that issue at oral argument here very soon. And then the last thing I just want to mention was longstanding Justice Department policies. I'm sure these are being thought about as the legal teams talk about the prospects for any kind of settlement. But there are serious limitations on the authority of attorneys representing the United States to settle cases. And this is referenced in the Justice Manual, but these principles go back to longstanding DOJ policies. If you're a DOJ lawyer, you can't enter an agreement that's going to essentially bind the government on a novel question of law. You can't convert some sort of mandatory duty or some sort of discretionary authority into some mandatory duty to obligate some change in policy or program. And you can't obligate the government to go spend money that Congress hasn't authorized. So there are real serious limits to what can be obtained in settlement. I think it'll be very, very interesting in light of the Ninth Circuit's order for dismissal, how the government in this administration, which from a policy perspective may find a lot of what the plaintiffs in this case are saying to be something they would agree with or at least sympathetic to, but they simply may not have the authority to do the kind of settlement or to entertain the kind of settlement that plaintiffs would like. The last thing I did just want to touch on, and this is just in the nature of rebuttal, there's been a lot said about the Ninth Circuit and some things the Ninth Circuit said about other issues beyond redressability. It was interesting and a bit, honestly, of a head scratcher for a lot of observers that instead of just addressing standing at the front end and deciding whether this case could be heard under traditional standing principles. The court began with other claims before getting to the standing analysis and ultimately concluding that that case had to be dismissed. And one of those claims was the APA claim, where the Ninth Circuit said, rejected essentially the government's position that these claims should be brought, if at all, as APA-based claims challenging specific agency actions. And the Ninth Circuit sort of stepped in that issue first, addressed it, rejected it in a sense, and then moved on to standing, found no standing, and dismissed the case. It's a little backwards from what I think most courts would have done in addressing that issue. They would have gone straight to standing first, identified that lack of jurisdiction, and dismissed. And then the one last final point I'll make is, in the context of the litigation, the Ninth Circuit makes it very clear at the very beginning of their opinion that they weren't accepting all of the determinations or findings or conclusions of the district court or even the evidence that was put before it by the parties. The court begins its opinion on page 14, quote, "The plaintiffs have compiled an extensive record, which at this stage in the litigation, we take in the light most favorable to their claim." So essentially, the court was recognizing that they're going to, in evaluating it, they were looking at all the claims in the light most favorable to the government or to the plaintiffs. So with that, I just really appreciate the opportunity to speak here. I do think it's an important principle that these issues are debated and should be debated and addressed in the elected branches, which is Congress and the executive. Thank you.
Thank you, Jeff, for so smoothly wrapping up your presentation. And thank you to all our panelists. I think everyone will agree that it's been very useful and interesting to have so many perspectives on this panel. I want to present the first question to all the panelists. Perhaps we can start with Julia and then to Jeff and Lisa in that order. But the first question is, could the panel give a quick 101 on how the federal government's sovereignty immunity is waived and inapplicable so plaintiffs are able to bring this action against the federal government?
Yeah, the Congress and the Administrative Procedure Act waived sovereign immunity for claims against the federal government that are seeking declaratory and injunctive relief. So if you're bringing a claim for damages against the federal government, you're in a different ballgame, but for declaratory and injunctive relief claims, you can sue your federal government.
And I think the government's position, and I have to go back and refresh my memory on the prior positions, but I don't think the government would agree that there's been a waiver of sovereign immunity such that this case could be filed, under the APA there is. And so those claims, to the extent they're justiciable, could be heard under the APA. But as a general matter, for the kinds of claims that are brought here, that's another argument that's been raised for, look, in our system, the sovereign is immune from these kinds of lawsuits unless Congress by law has opened them up in that regard.
Professor Heinzerling, I don't know if you also want to respond to that question. Otherwise, we can move on to the next.
You can go ahead and move on.
All right, great. This next question actually was originally, I think, meant for Julia and Professor Heinzerling, but Jeff, if you have any thoughts, feel free to chime in. But the question is, how do you foresee the relationship between the youth climate litigation and the critical environmental justice movement evolving within this administration? Should youth be considered an environmental justice group?
Yes, absolutely. I think, as you can see from the composition of the Juliana plaintiffs, 11 of our plaintiffs are Black, Brown, and Indigenous, and many are on the front lines of climate impacts and fossil fuel emissions and infrastructure. And so I think young people are part of environmental justice communities, right? And they are the most vulnerable members of those communities often. And so I think a lot of youth today really are integrated into the environmental justice and climate justice movement and are trying to work with the administration. And I don't think we're yet seeing the kind of progress that young people are hoping for on that front. But it's early, so we'll see what happens.
I would say that I think the movements are connected in the ways that Julia described, but also they're about, at a fundamental level, distribution and political power. And if you think about the rights of the youth, they're really, in some ways, in part, about the fact that they are going to suffer more, right? And in a certain sense, and I know this isn't the way you framed it, Julia, but in a certain sense, one can see youth always as the image of the future. And that's another point where the distributional consequences of climate change are severe. We are foisting this problem off on future generations. And there's, I think, a real intergenerational equity concern there. And in terms of power, political power, as Julia said, it's beginning. A lot of these plaintiffs still can't vote. That's true of children generally. It's also true very deeply about future generations. So I think they share some common themes, even if there's not complete overlap.
All right. This third question is actually, I think, targeted at Jeff. Scientists agree that climate change will be irreversible in about 9 years and that CO2 rates are increasing. Accordingly, can it be said that through the US's existing decarbonization efforts, could it be said that the US's existing decarbonization efforts are strong enough to mitigate harm?
I think that's exactly the kinds of issues that are being debated in Congress. You have a Congress and a White House that's aligned, and they're certainly looking at this. You're seeing a shift in a lot of positions and programs. But even if you take a step back and think about, okay, what has the US government been doing on decarbonization and reducing greenhouse gas emissions over a longer period of time? The Congressional Research Service did a report. I don't think they've updated it in the last 5 or 6 years, but it showed that between 2008 and 2013, the US government had spent in federal programs over $77 billion on climate-related programs. And I know that number, if you take it over the last 20 years, is astronomically higher and will all in all likelihood grow. And that doesn't include the billions of dollars in private investment that is going into decarbonization in the United States. I think one of the remarkable things to watch has been how private equity has moved in the direction of investment in renewable energy. I think I read a statistic that was something like last year was $23 billion, if I have it correctly, in private equity investment in renewable. But I think the US has been a world leader. It continues to be a world leader in decarbonization. The trends are positive for the United States. Again, 13% decline from 2005 levels to 2019. We saw even more decline in 2020, obviously because of the epidemic. But looking ahead, the US is committed to further progress. I think the big question is, how do you calibrate that with regard to ongoing science as well as ongoing action by other countries, where really reductions are going to need to be seen in a dramatic way also.
Do either of the panelists want to respond to that question as well?
Well, I was wondering if Jeff knows the figures on how much is spent by the United States on fossil fuels and that component of our energy system, because it's far greater than, you know, the amount of money and land and resources spent on renewable energy.
Yeah, I don't know the relative weight between the two. I would say the investment's been dramatic. New nuclear technology, small modular reactors, renewable power of every form, energy storage, sequestration. The US government has moved a lot in the last decade on that front. I expect you'll see that continue to grow. And again, US private equity investment and other investments been brought to the table as well in a pretty remarkable way.
Yeah, and I guess I'll just say, you know, I think what you presented is precisely what courts are empowered and qualified to look at, is hearing evidence on, you know, looking at the conduct of the federal government, and does it rise to the level of a constitutional violation? You know, do those programs and systems violate individual rights? And that's precisely what courts do, and having that evidence before it is well within, you know, its purview. And so the question is not, are these good policies, right? Like, we're not here to argue about, are these good policies? Is this what the majority of Americans want? We're here to ask the court to determine, are these policies constitutional? And that's a different question.
Julia, I think this next question, it's a little bit, you all touched on this just now, but I think you especially covered this in your presentation. What's the significance of the government's affirmative actions versus their failure to act in the Juliana case?
Right. Yeah, so the biggest significance is our rights to life, liberty, and property under the Fifth Amendment of the Constitution are what's called negative rights. So the government doesn't have an obligation to protect our right to life, for example, as a positive right. They don't, if you are threatened by somebody else who is not acting on the behalf of the government, then the government doesn't have to step in and defend your life. But what the Fifth Amendment says is that the government can't act in ways that deprives you of those without justifications that pass the thresholds for the tests that the Supreme Court has set, like a strict scrutiny test for a fundamental right. And so we can't bring this case for pure failure to act. We have to look at the government's conduct and then challenge that conduct as depriving these youth of their Fifth Amendment rights. And so that's the significance of it.
Oh, can I address that just briefly? Lisa, you go on.
Well, I would just say, I think that doctrinally that's exactly right, obviously. But I just say, I sort of am surprised that in this day and age, we still insist on distinguishing so sharply between action and inaction, when any first-year law student should know that they can reframe any action as inaction and any action as inaction. And the two are very easy to reframe as each other. And so little should turn, it seems to me at least, in the legal system, the distinction between those two things, especially when, as here, the actions and any failures to act are so completely intertwined, where it's almost hard to tell whether forbearance of government enforcement, what is that? Is that inaction or is that action in support of the fossil fuel industry? So I'm always skeptical, even though I realize that our system still remains built kind of structurally and doctrinally on this distinction, this hard and fast distinction between negative and positive liberty. I'm skeptical about how really predictable and clear that distinction is.
Yeah, I think just with regard to Julia's point about fundamental rights, I didn't have a chance to cover that in much detail in my remarks, but the Supreme Court has made it very clear that to recognize new fundamental rights, they must be the kinds of rights that are deeply rooted in our U.S. traditions and principles. We don't see that with environmental rights like we do with education, the right to marry, and other kinds of rights that the court has recognized as fundamental rights. And this is not an issue that's uniquely come up in this case. It's come up with regard to the right to a healthy environment over the last 3 or 4 decades. It's been brought up time and time again. And each time that argument for the court recognizing a fundamental right as a constitutional matter to a healthy environment, a clean environment, or a safe climate, the courts have rejected that. That Third Circuit 1980, Fourth Circuit 1971, Sixth Circuit 2019. Now I think more recent cases have continued that trend. And so I just think, again, it may be a distraction, I think, from the overall policy agenda that the plaintiffs would love to pursue, to focus so much effort on the courts when their real remedies, their real redressability is going to be on the international stage and on the domestic stage through their elected branches.
That actually leads to the next question, which is, if the democratic process is broken, as we see now in the US Senate and gerrymandering and voter suppression, is it plausible to rely on the political branches as an excuse not to have the courts intervene?
Yeah, so, whether the political branches are broken or not doesn't change our constitutional structure and doesn't change the role of our courts in that constitutional structure. And I think, it still goes back to the central point that you know, there have been many constitutional cases brought throughout our history where the courts are asked to deal with new circumstances and to apply constitutional and bedrock law to a new set of facts. And that's all we're asking the court to do here. And, you know, with all respect, Jeff, you're just wrong about the history of the United States. So there are these ancient laws that come from Roman times that were passed down to the United States, including the public trust doctrine, which is all about protecting air and water and shorelines and forests and species. There's a really deep and rich history of environmental protection in our country. The framers and founders of our country were farmers. They were climatologists. James Madison, who wrote the Fifth Amendment, said in a speech the year after his presidency that the atmosphere is the breath of life without which we all perish. And he was concerned about climate change in 1818. So, you know, and this is the kind of history and analysis that courts are responsible for conducting. And this, you know, it wouldn't be me and Jeff arguing about this if the courts really wrestled with these issues in the Juliana case. And just, you know, to touch on, I see this other question about the settlement issue. And, you know, Jeff was talking about how the Department of Justice can only settle cases in a particular way. But it's really important for everyone to understand this case is not against the Department of Justice. They are not the defendants. It is executive agencies and the Office of the President that are the defendants in this case, and they are the clients, and they determine what kind of settlement to agree to. And they can settle cases that is, as long as it's constitutional, as long as it is within their executive authority and statutory authority to do, and they're not violating an act of Congress and they're complying with the Constitution, they can agree to a settlement. And the Juliana plaintiffs have never been interested in dictating specific policy measures. What they want is they want the energy system to not be destroying their lives, and they want standards that protect their constitutional rights. So this is not about being policy prescriptive. I think, you know, the public and Congress and the executive branch should be working on policies and debating those issues, but there need to be standards that protect fundamental rights. And that's what this case is about.
Lisa,
May
Jeff?
I say something?
Yes, of course.
Oh, Jeff, did you want to say something?
You go first, Lisa. Thanks.
I would just say that I think that this question about, does it make sense to talk about the democratic process here if it's broken? I would first point out it's broken partly because of the Supreme Court itself, in my view, that the Supreme Court has abetted the process of breaking U.S. government in, for example, Citizens United case, in cases on gerrymandering. And so I don't think it seems like it's kind of rich for the courts to say, well, we can't get involved in the political process when they've been involved in breaking that process themselves, and when they're in the business of, it's all very fine to say, oh, you should go to the political branches in the name of separation of powers. When this Supreme Court has been more activist and aggressive in striking down federal legislation based on the separation of powers than any court in recent history. And so even if Congress lumbers to its feet and passes a statute, it may face a brand new kind of non-delegation doctrine that's ready to strike it down. Right? Look at the history of the Affordable Care Act. The court hasn't been respectful of the legislative branches there. So I understand. I wish Congress would lumber to its feet, but I also worry about the court being ready to pounce if it does.
I know we're close to being out of time. I think there's the one parting thought I was hoping to share. And if the question on the table is whether democracy in the United States is broken and the Constitution isn't functioning properly, I want to be on the side of those who say the Constitution is working, our democracy is working, and that these are complicated, difficult questions in a very diverse, complex country. And our Constitution sets up a very robust mechanism for these things to be hashed out, debated, and then decided. And the United States has been debating and has been acting on these topics And it's for everybody on the call to participate in that process. And that's the way the Constitution designs for it, and that's the way it should be. And I think the Supreme Court's mechanism, understanding jurisprudence, is designed to protect that very thing. The same with separation of powers, the idea that these are properly safeguarded and dealt with by the executive and legislative. And I think those are principles in the Constitution that are worth defending. And they're the same kind of principles that, as we reflect back on Memorial Day, the same principles that those who've given the ultimate price have fought to defend. And I think that's on us to participate in that system in exercise of those rights that have been purchased for us. So I really appreciate the debate and the discussion, and it's an honor to be part of this great panel.
Before I cut off the debate, I think there is just one question left that we have time for. I apologize in advance for not getting to all the questions. They've been really, really great. But this is to Julia. Julia, could you respond to Jeff's assertion that the Justice Department may lack the authority to reach a settlement with the Juliana plaintiffs?
Yeah, I think I partly addressed that, and I think the answer is no, they don't lack authority. There are many examples where the Justice Department and the US government have settled cases through consent decrees, and when multiple sovereigns are participating in really complex issues over water disputes or treaty rights. So I don't think that's accurate. And I'll just close by saying, I think, we have many fundamental rights in this country, right? And they include rights to speak freely, to practice our religious beliefs, to own a gun, to personal security, to marry. And I don't think many people would want our politicians to be debating whether those rights actually get protected or not. And I think, people who lean more conservative would not want this Congress deciding whether they get to really have their religious freedom. And it's why many religious groups have gone to the courts during COVID to challenge restrictions that they perceive to be unconstitutional. And there is, that right is not more sacred than the right to life of these youth or the right to their personal security. And to say that these children's personal security and their rights to life and their rights to their very homes and communities should be put to the vote of politicians and not protected by our court is in and of itself politicizing our courts, because it means our courts will step in on religious freedom and step in on First Amendment speech and step in on gun rights, but won't step in when children are being harmed by their government with the climate crisis. That's a political act by our courts. And it's unconstitutional, and it flies in the face of what our founders intended. To not protect children in the biggest crisis our country has ever faced is a political act by our courts. And I'll just conclude with that.
Thank you so much, Julia. I realize we are officially out of time, but I would like to give a moment for Upasana, Jeffrey, and Lisa to just have any concluding remarks. Thank you all again for this incredible discussion. I really wish we had more time, and also thank you all for your questions. Unfortunately, we weren't able to get through them all, but I highly encourage you to stay engaged and keep following the developments in youth climate litigation in the US and throughout the world. Upasana, if you would like to go first, then Jeffrey and Lisa. Thank you.
No major closing remarks for me. It's just been very, very useful, fruitful to hear this conversation. And again, so many perspectives. I'm approaching this issue kind of from an international law perspective. So to dive deeply into US jurisprudence and kind of the history of rights in this country has been very, very enlightening for me. So I want to thank you, Nina, for inviting me to participate. And I'll turn it over to Jeff and Lisa for their remarks.
Thank you to ELI. Again, just a real pleasure to be part of this conversation, and we look forward to other opportunities to engage with this panel or other panels on this topic. And I think it's an area of interest for the public for good reason, and so we'd be glad to participate in that. And I want to thank my panel members for this great discussion.
I'll say exactly the same thing. Thanks so much. These are really important issues, and I'm just glad to be here in this productive setting talking about them.
Wonderful. Perfect. Thank you all so much. I'd like to give one final big outstanding thank you to our wonderful speakers. We really appreciate your contributions to today's webinar, and thank you for lending your renowned expertise and leadership to make this such a fascinating and informative program. Thank you all, and stay well.